Drum roll, please. Hope you can hear that. I get to bring you some good news for once. Hooray! Some of you political junkies may recall that back in July, the state of Kansas, good old Kansas, passed a law that prohibited the state or any state contractors in Kansas from doing business with supporters of the boycott, divestment, and sanctions movement against Israel. The movement was a political protest, or is a political protest, that is aimed at Israel for its treatment of the Palestinians and the illegal occupation of their territory. The great Glenn Greenwald explains further in The Intercept. The enjoined law enacted last year by the Kansas legislature requires all state contractors, as a prerequisite to receiving any paid work from the state, to certify that they are not engaged in a boycott of Israel. The month before the law was implemented, Esther Kuntz, a Mennonite who works as a curriculum teacher for the Kansas public school system, decided that she would boycott goods made in Israel, motivated in part by a film that she had seen detailing the abuse of Palestinians by the occupying Israeli government, and in part by a resolution enacted by the National Mennonite Church. The resolution acknowledged the cry for justice of Palestinians, especially those living under oppressive military occupation for 50 years, vowed to oppose military occupation and seek a just peace in Israel and Palestine, and urged individuals and congregations to avoid the purchase of products associated with acts of violence or policies of military occupation, including items produced in Israeli settlements. A month after this law became effective, Kuntz, having just completed a training program to teach new courses, was offered a position at a new Kansas school. But, as the court recounts, the program director asked Ms. Kuntz to sign a certification confirming that she was not participating in a boycott of Israel, as the Kansas law requires. Kuntz ultimately replied that she was unable and unwilling to sign such an oath because she is, in fact, participating in a boycott of Israel. As a result, she was told that no contract could be signed with her. Unbelievable, right? I guess if one state was primed to persecute one for their political beliefs, progressive political beliefs, it would be the insanely draconian Kansas. In any event, Kuntz was able to retain the ACLU, who represented her in this case. They sued the Commissioner of Education, asking the federal judge in the case to enjoin the enforcement of the July law based on obvious, in my opinion, First Amendment grounds. Just for context, let's read the First Amendment again. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people to peacefully assemble and to petition the government for a redress of grievances. The ACLU's suit said that the government was violating her free speech rights under the First Amendment. The great news? The court agreed on Tuesday and has preliminarily enjoined enforcement of that Kansas law. Writing that his injunction was in the public interest, the judge asserted that the United States Supreme Court has held that the First Amendment protects the right to participate in a boycott like the one punished by the Kansas law. Kansas Governor Sam Brownback, a Republican who supported the anti-BDS law, criticized the injunction and the ACLU, which is representing Kuntz, as I mentioned before, in the case. I think that they will lose on appeal, Brownback said. These types of laws have been passed for years at the federal level, whether it's on Iran or really a number, South Africa and apartheid. You've had laws like this for years, and they've been upheld. Needless to say, Governor Brownback is not an honest actor when it comes to Israel. Last year, Brownback went on an unpublicized 8-day trade mission to Israel in late August and early September that included a meeting with Prime Minister Benjamin Netanyahu. The trip came a month after President Donald Trump nominated Brownback to serve as U.S. Ambassador at Large for International Religious Freedom. Interesting. But Brownback administration officials said the trip promoted Kansas businesses and sought to further ties between the state and Israel. The Hutchinson News reported that the State Department of Commerce said the schedule in Israel from August 26 until September 2nd included visits to Israeli businesses and discussions, a stop at a hospital, and discussions of irrigation and water treatment. The department estimates the cost of the trip at around $32,000. Brownback's office issued no news releases before, during, or after the trip. And of course, pro-Israel donors are his 6th largest industry donors in his career, totaling nearly $275,000. But this fight is not over. It could be overturned on appeal, as Brownback so gleefully said, yes, but the stifling of anti-Israel sentiment is happening in other states in the country, as Greenwald points out. Democratic Governor Andrew Cuomo issued an executive order directing all agencies to terminate any and all business with companies or organizations that support a boycott of Israel, and requiring that one of his commissioners compile a list of institutions and companies that, either directly or through a parent or subsidiary, support a boycott. Last year, a measure sponsored by Benjamin Cardin, a Democratic senator from Maryland and an AIPAC loyalist, joined by 43 other senators, went even further, purporting to impose prison sentences and large fines for anyone working with international organizations to boycott Israel. And Greenwald lists even more examples. Look in the description below. Here's the thing. If the First Amendment is meant to do anything, it is meant to protect American citizens when they disagree with the policy decisions made by their government, domestic and foreign. Just because the Republican Party and most of the Democratic Party is so far up warmonger Netanyahu's butt doesn't mean that the rest of us have to be. The American citizenry has no obligation to protect Israel's endless illegal occupation of Palestine from being criticized. In fact, I would argue, as Americans, it should be in our DNA to protect those being occupied and being denied their rights by a more powerful actor. We are a nation that declared its independence from Great Britain. Remember that, guys? It's pretty important. Making the free expression of dissent illegal, especially about the occupation of a larger actor on another country, is as un-American as it gets. So good on this federal judge for doing the right thing, and I hope it sticks. It really amazes me how much crazed influence the pro-Israel lobby has over the politicians in this country, and will continue to have. Shame on Governor Cuomo, by the way. But I'm happy that this Judge Daniel Crabtree, that's his name, was free from their influence and was able to see this law for what it is: discriminatory, anti-American, unconstitutional political censorship. And we should never let it happen in this country.